Mukama wange si yote hiyo mukama wange kantandike naye mukama wange dakiikeemu.
I am not fine.
Okay. That is Martha Karua for you, ladies and gentlemen. She is already in court. Counsel Michael Chintu. Counsel Michael Chintu is also here. It is Dr. Kizza Besigye in court today. The sister to Winnie Byanyima. The sister to Winnie Byanyima. Alright, we are live. Just subscribe, share, like, and comment. Honorable Councillor Mike Chintu is around. Martha Karua for the defense team is also around. Opposition leaders are all here, digging trees. Subscribe, like, and comment, share this one, and we'll make it happen. Goli senior ngamba vugambe nti mutabani wange. Joseph, thank you. Subscribe, like and comment. share everything as we're moving. Lwaki nkusaba gundi lwaki nkusaba okunteeramuko bana akatandika eddakiika 5 wano waliwo akasannyalaze musawo emu erabandi mukaasa
erabawo gakoze mangu awo
erabaawo gatambudde. Honorable, good morning. What should we expect today as we are, because the doctor is already in court?
Well, I don't really have any expectations from court or any positive outcome. For me, it's going to be the usual. The chairman comes in, they intimidate our legal team, judge, advocate, their prayer remains our legal team, that is what is final. Then they bang the tables and they say the case has been adjourned. Honestly speaking, I'm not expecting any miracles. I'm not expecting any good news. The president said when our counsel Kizza was brutally arrested and then convicted without even trial, without taking plea, says a lot. Says a lot, it communicates a lot. So I don't expect any fairness. I don't expect any justice. And clearly, for today, you have seen what is happening at the court matter. Most of our activists, those that came walking, have not been allowed access, and the deployment, so it starts almost 3 kilometers away from the court. So I don't expect fairness, I don't expect justice, I only expect a repeat of what happened and so on. But that said, we are not going to be intimidated, we are not going to give up, we shall come here and defy, we shall come here and fight and do the level.
Honorable, any updates on Counsel Kizza, Aaron?
Well, I visited Counsel Aaron when I just
after the
after
yes.
And of course it was painful. Aaron at a personal level was a friend. It was painful seeing what they had subjected him to. And he was in a lot of pain. First and foremost, he was limping. His ears were swollen and he had scars all over his body. He also confessed to me that most of the severe torture was in the ribs. But also what scared me the most was that when he breathed, his air smelled blood. And for me, most likely he suffered internal bleeding. So Aaron is not supposed to be in Italy at the maximum prison. Aaron is supposed to be at a well-equipped hospital for the civilian. I never called the president of Ghana to say that, and he told me one of the things I need to consider is ensuring that Aaron gets.
Thank you very much. Honorable, good morning. I see you are not in the mood. I think because of this situation which is going on here. Tell us, what do you expect today in this court martial today?
I expect nothing other than the usual brutality, the arrest. Even I came from home knowing that I can be arrested from here, I can be sentenced to a year or more than a year. So I'm ready for anything. We don't expect justice. There's no justice here, there's no fairness. So we just expect the worst. But we are ready for anything. We are ready to take it.
Any update on your counsel, the defense counsel?
He's in pain. We have not had medication yet. And they give him he was charged illegally and he's protesting it. So he already has given instructions to his lawyers and they are filing some petitions against this conviction. And we expect any time the High Court or the Constitutional Court will pass this conviction.
Thank you very much, Honorable. As you see, the situation is moving smoothly. Right away here, I want to take you to Honorable Kenny Muchamuzi. Is also present. Honorable, good morning. I'm sorry to interrupt. Yes, but the viewers are watching you live here. We have some viewers watching you live here, Honorable. What do you expect in today's court in summary?
Because I don't see this standing case for Besigye to answer. If one has no jurisdiction to arrest the person whenever he was arrested in Kenya, the court can be convinced that the attackers do not have jurisdiction. The case will collapse there and then. The Besigye to be an innocent person.
Last time we saw Counsel Kizza being rooted and arrested. Do you have any update on Counsel Kizza? Have you tried to visit him? Have you heard from him?
Yeah, we have heard that the lawyers have visited him from wherever he is. I think is that place?
Italia. But every Kizza's case is very simple. I think he has gone to the Constitutional Court to seek an interpretation as to whether the military court has the powers to sentence him without being heard, contrary to Article 44 and Article 28 of the Constitution. Thank you very much.
Once court determines that the military court does not have powers to sentence the standing case will collapse and punishment given to you will collapse.
Thank you very much, Honorable Kenny. I'm one of your voters. President of Abu Wali, Honorable, good morning, sir. Yes, a little bit of what is going to happen, about what you expect today in the court.
Well, we are in a military facility. We don't know what's going to happen. People here don't have common sense. They don't see. They don't reason. They are only ordered. So we don't know what orders they have, what instructions they have. When you are here, you have surrendered to the military. So we don't know what the military people will do in the court. In the hall. Wait to see what happens. We know that they work on orders.
Have you tried to visit Counsel Kizza? Do you hear from him as we saw what transpired last time in the court?
Well, I'll be visiting him tomorrow.
Okay, thank you very much. That is honorable for you. There's a lot of stories here. There's a lot of Just tap the screen. Subscribe, like, and comment. Subscribe, like, and comment. Subscribe, like, and comment. Subscribe, like, and comment. I want to take you to the councils. The team of councils over there. Bwenagenda banasumbuwa. Davis. Bwenatuukawo wali bayinza okubaamu n'obuzibu bwonna. Wali eri? Bakanso we bali. Bye balimu. Okay. The team of councils, some of the councils who are going to stand for Dr. Kizza Besigye is over there, as you see. Just tap the screen, like, and comment. We are going to give you full coverage of this one. It is Dr. Kizza Besigye already in the court. It is the court martial here. It's where we at, Makindye. And for the viewers here, for those of you who don't listen to English, tuli ku kooti yamajje okubeera nga ate tulaba nga ekiddako kyonna tukigoberera wano butereevu. Ensonga nyingi nnyo ezigenda mu maaso, naye twagala okuba nga tufuna abamu ku bannamateeka oba emu ku legal team ey'abannamateeka egenda okuba nga eyimirira mu musango guno ogwa Dr. Kizza Besigye. Eyo ye ttiimu gy'olabaawo ejja. That is the team. That is the legal team. First, they come around, and Council Area Shirukwago is also on the team. That is the legal team as you're seeing it. Kanso katono nye dakiika emu muje mbasabako ne mukama wange wane dakiika tuwulireko ebisuubirwa olunaku olwaleero. Ndaba babadireyi nga babaza wano babaze eri. What is going on? Council tubulireko ku mbeera ya mukwano gwo gy'alimu kubanga we know is your tight friend and is your workmate. Yes, tell us about the situation. How is Uncle Aaron?
Aaron ye mugumu olwokuba bamukuba kintubyemwabiraba nga tugenda mu maaso mu kooti naye kyesanye kiriwo kisobola okugumirako kati bagezezaako era ali olunaku olwajjo bwe twamulabye aweereza okubakiriza n'agamba nti abali eyo yomu alina okuguma ero naali mukomera olwokuba yavaayo okulwanira ebigatto yavaayo okukola omulimu gwe amateeka yavaayo okujja mu kooti masho kubaraka nti amateeka gafuka eggwanga naye kifuka eggwanga lino constitution yaffe semateeka waffe era kye balina okuyiga okusoma ensonga lwaki ali mukomera n'okutuusatiisa balooya abalala okubagoba mu kooti basubire Dr. Besigye n'ajja kumutala.
Counsel Mike Kintu, tubulireko ndaba babatambuza bakuba baze eno babaze eri. Why are they delaying this?
bayongeramu obuwaayiro obulala okutukkiriza okuyingira olwaleero tulinako ku ssabbiiti etono nti tebatuyisizza bubi nga tuyingira essimu zaffe bazitulekedde bategedde nti oli looya bakusabye ID eraga nti oli looya ne batukkiriza nekuyingira naye kati tuyingira mukuyingira wano batusabye lisiti era tugibakwasizza eraga bannamateeka abatuufu bakkiriziddwa okuuza omusango era nga bakkiriziddwa bakirante baffe abali mu kusira so lisiti eyo tugibawa eriko balooya 39 era tubalinze basome omusango gwaffe tugende mu kooti naye ng'ekireese okugirenga lisiti ebadde ekyafayiringa twagireeta wano ku Lwokutaano tugifayiringe naye alisiivinga empapula za kooti mu rejisito ya kooti eno teyaliiwo so tugikedde lwaleero kugireeta tugifayiringeyo era ebibadde bikyagenda mu maaso nebituwisizaamu tulowooza
mukwano gwo ate nga tubalaba mukola omulimu gwe gumu munnamateeka Aaron Kizza ali mu mbeera ki? Have you tried to take to
Kizza twagenzeeyo ne tumulabako era bamutuwadde ekitalya ali mu mbeera si nnungi naye ekyomukisa omulungi nti ali ku bujjanjabi mukomera mwala naye nga yakubwa nnyo ffe tetwategeera nti bwe bamukwata nga tuli mu kooti ne basooka ne bamuleeta mu kabuli ka kooti ate ne bamugjawo ne bamutwala mu kkomera lya kooti n'abeera eyo mu kkomera eyo yakubwa nnyo n'atuuka mu mbeera nga tasobola na kussa era yatunyumiriza nti basibe banne ne bamutaasa ku bannamagye abaali bamukubira mu kakomera ako ak'ekkooti eno era bwatukwezibonda naye ekyomukisa omulungi agenze arespondinga ku ddagala era agenda ategeera kitwalabi era n'atugamba tusigale nga tulwanira emitendera.
Counsel, abantu abakulaba mu diaspora, they want the English version of what you've been talking about.
Okay, yeah. Today, this is the 13th day of January 2025. We have come back here to court, us as the lawyers of Dr. Kizza Besigye and Haj Obed Utaleka. The reason we have come back today is because the case was adjourned today. However, we have gone through the normal routine check procedure of this court, but today they have changed it a little bit, that they have accepted us to come with our phones. The moment they realize you're a lawyer, we are told to identify yourself, then they take all your documents that confirm that you are a lawyer, they leave you with the phones. Now, we have a problem that last time they instructed us to file a list confirming all the advocates and lawyers who were instructed by Dr. Kizza Besigye and Haj Kamlex to represent them. We brought the list on Friday, and unfortunately, their registry was not open, and the person who is supposed to register all documents. So we have filed today in the morning. We have filed today, but it has taken time. That's why we are late. So right now they have told us that they have finished registering our list of all the lawyers representing them, and we are waiting for them to read our file and call us. So we don't know so far what we are playing around, but we are waiting to be called.
On your best friend, yes.
My brother, Counsel Kizza, we went there and checked on him on Friday morning in Chitalia. He's responding to medication. As you may remember, the way he was battered in court, you were journalists, I saw you and I saw him. So he was battered, and the way he was battered in court was no way compared to the way he was compared when he was taken outside court in a court cell. There is a court cell where they take suspects and accused persons. So while there, Aaron Kizza was beaten and battered beyond human.
However, his fellow inmates who were in that cell came to his rescue. They saw the battering that was beyond inhuman. They said this can't continue. So they stopped the soldiers who were battering him, and they stopped. So at that point, he was brought back to court, sentenced, and sent to prison. Now, on Friday when we met him, we are happy to inform you that at least the prison officers have a hospital for him, and they are trying to treat him, and he's responding well to the medication. We are only praying that he properly responds and recovers properly. Today we are here to continue with the struggle for the rights of the Besigye and Adjournment. Together now with President, as you remember, there were 2 accused persons, now there are 3.
Yeah, I understand. Thank you very much, Counsel Chintu. Mike.
It is okay. It is okay.
Also, Wanda, good morning. Counsel Wanda, good morning, sir.
Morning, sir.
What should we expect today?
Today, we expect to proceed in court because they are pending things like the ruling, so we are hoping court will give us the audience, the ruling, and then we shall proceed with the matter. Yes.
Let me not delay you because I see counsels. I wish I'll get back to you.
Okay, Ogul Cyrus.
I'm present.
I take your picture.
Yeah.
I need your picture. Okay. Tulina mukama baya. Tumusime kato. Chintu Michael.
Counsel, slowly as we do this procedure, check it.
Okay.
Slowly.
Are you going to read my name?
Paralegals.
Okay, now
I think Chintu Michael. Okay. Kato Wilson. Wimbaz Nalukola. One Kabdala. Akachimpa Godfrey. Wanda Ronald Samuel. Ernest Kalibala. Frederick Jempanga. Ernest Azim.
So the next time.
Tugume Moses. Apollo Katumba. Sekade Julius Fox. Samuel Muizi Mulindwa. Kabuya Lawrence. Please go straight on. Go straight on.
Do you know where Ingrid?
Go to the next one. Second Jaka Akachimpa na msomi Godfrey.
Are they there?
No, ni wa msomi.
I see.
No, ni wa msomi. Ya no? Then I'll read you. Proscopia Kunihira.
Then I also read the matter.
The political actors wait this first and this. What was Guru? Wait from there. We shall let us sort of this and come back. We shall come back for you.
For us, we don't need a list.
Press. But you must be given to enter. Communicate the rest first seat. We can wait the rest person to enter. You can leave the room at that minute. Communicate to them. Okay.
Genda mu kkooti.
Okay. Let's go first of all, go back. Yeah. Then we shall have let us come for you.
I found even the media. I found even mubuuze nnyawulire.
I'm not a visitor, this is court. This is court.
Yes, but the court has agreed. Let's have some politely, kindly.
I don't want to see.
You don't understand.
Just clear. I don't want to stand here.
Mistake.
Hey.
Kkooti lwa kkooti.
Clarification, the first communication was we wanted only the lawyers to first take their seats. Okay? Then next will be political leaders. Yes.
What about us parents?
Yes,
We've been in many courts.
It's okay.
Parents sit first, the public sit, the lawyers come, and the chairman comes.
That's
But for you, you do it the other way around.
That's your procedure, not our procedure.
If you are court, you must behave like court.
You must, but what's important, don't go to court.
So what there is to parents?
Doctor, after lawyers, doctor.
What's going to happen is that so, and the rest, even the public, so allow me to invite the political leaders.
And the aunties.
We do that, and I come with them with political leaders only.
How about the daughters?
Doctor will come after, please.
Ate Ingrid, yes, political leader. Yakayagala mukwata.
That is our chairman, Nakaseke. Yes, he's the chairman, Nakaseke. He traveled from far.
Honorable. You're also political leader. Again, you're a political leader. Parent.
What did you do? That is our chairman, Kawen.
That's the chairman of
I can give you the list of political leaders if you want. I can write.
So now, the other one
And now, Dennis?
Counsel Elect Dennis.
Then Kabusu.
Chairman w'abavubuka kooti yetutte yayambadde kooti ayimba afanda and press press we are the last people. That's how they want it. Press.
Abayiga temutambula temukyali bapolipolina
Excuse me, can I move? Who decides on
Eventually. Nobwedda onasaba busabi tuyingire.
Nako abantu
Nabo bamanyi awo. Kituufu. Nti mbadde nkyatereeza wano. Emesagi kweziri.
YouTube or Facebook?
YouTube. You tell me when it's back, you tell me when it's back. It's all about network. When the volume is off, you just get to know that the network is kind of disturbing. But you let me know when the volume is back. Yeah, they tell me the sound is on. Paulo Kasawa mukama wange ebiri mundu genda bifuna naye ya proceed no court yamajje. This is a court martial. Yes, kindly just tell me where are you watching from? Where are you watching from? Where are you watching from? Just write down where you watching this one from, and subscribe if you're not yet subscribed. We make it happen. This is the heavy media giving you the heavier information. Live from Mbarara, Matthew Mwesigwa. Thank you for watching. How is Mbarara? Hope you're doing good. Yes, from Dubai, Qatar, Abidjan, from Gaza, Kisoro, Amos, matching from Florida, USA, live from Kabare, Ali. Just tell me where you're watching from. Where are you watching from? And we make it happen. Ginger. Yes. My people are watching from Gulu, I have my people here watching from Kibale. Peter.
We are also tired. We have been here since.
Wanasubiri kwanza tuje na baba clear wait no more clearance until I take clear first ya clearing now bed huko sika warudi nyuma I want you I hope you Yes. Tell me, where are you watching from? I'm already in court. For those of you who wanted me inside, I'm already inside. I'm like, my counsel's here. Okay, we are waiting. We are going to push them on the
kyo kino kyekikyo etabulesi stand what about it? Soko jike nze sivaawo awo nno waliwo oli omusajja wa BBS anti ngamba ono omusajja wa baba wano waliwo wa BBS anti Justin mbadde namukwatidde akafo Moroto, how are you? Yes, Ronald, thank you for watching. Tell me where you're watching from. We are just waiting for the judge. How are you, my people from Fort Potro, live from Lulina Kulawa? Anti Kati Jangu, they can freeze them. Davis, toka gazia nyo. Yo nene kituufu. Muwe muwali. Ate wanayo no gaya akolaganika naye. It is just only fighting for spaces here. If you don't come early hours, the first on the list. Heavy media, heavy information, heavy footage and everything. It is yours truly, MC, original MC. Have you had subscribe, like, and comment? Subscribe, like, and comment. Subscribe, like, and comment. Subscribe, like, and comment. Mkulima.
my name. Together with Captain Lieutenant Gam, Second Lieutenant Regina Nazar, and I shall also be doing Second Lieutenant Arthur Phillips. Those are the items for the statement.
As you, Honorable Chair, Honorable members, my name is Amis Kakwala. I appear under the leadership of Senior Counsel Martha Wambari Nagua, together with Honorable Diaz Wako, Mr. Tukumi Moses, Ms. Kumihira Proscovia, Mr. Silas Kubur, Mr. Peter Nightway, Mr. Bayan Namkama, Mr. Tumusimi Kato, Mr. Michael Chintu, Mr. Abubakar Sekan Yako, Mr. Kato Wilson, Mr. Mimbazi Elias Alcola, Mr. Katimpa Godfrey, Mr. Wanda Ronald Samuel, Mr. Frederick Kupanga, Mr. Katumba, Mr. Gabriel Lawrence, Mr. Julius Paul, Mr. Samuel Luis Bigwa, Mr. Chizito Farouk, Kamlegia, Mr. Enab Dennis, Mr. Moses Kabusu, and the other counsel who is not present is Mr. Kizza, who is still counsel for Honorable Chair, we have some housekeeping issues that we need to deal with before we the Chair allows. Handled by my starting off with the Senior Counsel. I apologize. I believe it is
the court. One of the housekeeping issues is regarding our right of access to the court as advocates representing the suspect in the law. And looking at regulation number 60 of Uganda People's Defense Forces Act, regulation number 1. This regulation gives you, Mr. Chairman, the duty to ensure that this court functions as any other court of law. And in any court of law, advocates are granted access to the court to be able to do their duty to represent the accused persons. because of what transpired here last time we were here on the 10th, when Aaron Chisa was denied access and it resulted in him being jailed, we are most humbly seeking your assurances that as advocates, we are not going to endure any intimidation or obstruction as we come into court to do our duties. I must state that what transpired has caused a lot of shock. If you can see, we are lesser than we normally are. It has caused fear and intimidation among the ranks of advocates, and we thought that we needed to bring to your attention that this court needs to show and to demonstrate balance, not just the welfare of the military officers before it, but the welfare of everybody in its presence. So we are seeking assurances that we'll be able to represent our clients without intimidation. And today I must state that we have ease of access unlike other days. Today we have even been facilitated to sit together where we can be able to pass things to one another. We thought we should bring that. The other issue is of officers who are manning the court not having their name cards. So we are not able to know who is interacting with us, and it is necessary because it's procedural that any officer who is officiating at the court should be disclosed. An issue that is may not appear very relevant, but it is. We have noticed the changing composition of the court, that sometimes one or two members are replaced, and we are requesting when that occurs, kindly let us know who has been replaced and the names and the rank of the person representing. You remember that at the start of the court, the names and ranks of all members of the court were read out. But at that time, these two gentlemen, so when they change, it throws us off balance. We are not able to know the composition of the court, which is a requirement. We have other housekeeping issues, which I will leave my colleagues to add to. And maybe before he rises, to my colleague, professional colleague, the judge advocate, just to tell him that, yes, I'm from Kenya, but I'm East African, and have an East African passport. So the unkind reference of me as a foreigner is not, last time, it's not applicable. I'm an East African holding an East African passport. So apart from being licensed to practice law here, I come as of right being an East African. There is one other issue that I was required to mention before I hand over to the Lord Mayor. It's just about the terminology. The last time, the judge advocate actually said that I could also be subjected to contempt proceedings for referring to this court as a tribunal. Whereas we are trying our best to keep saying court, I just wanted it to be on record, Mr. Chairman. The word tribunal is not derogatory at all. Tribunal refers to a court in the Oxford Dictionary, and I hope my team has come with the photocopy. It refers to a specialized court, like yourselves, which is dealing with a specific court, a specific. You are not dealing with general matters. For instance, a Ugandan who is a landlord cannot come and file a claim against the tenants before yourselves. You are settled for a particular purpose. That's what tribunal means. And therefore, I will plead with the judge advocate, please let us give the proper terminology, proper interpretation, because they are bound to take your interpretation if nobody objects. But if we object, then the court, led by the chairman, has a duty to see whether our objections are valid. So I would like to refer to the English.
For me, if I may interject, the word court is defined in the People Act. We are not going to adapt the dictionary definition. Use the UPDF Act to define what is the meaning of court. And that is the one we shall go with.
That exactly is our problem.
Which was enacted by the parliament.
It is true.
So I would say that unless you go back and start it from
Mr. Chairman, we seek your indulgence in listening to our objection. The English language is neither defined by the UPDF Act or even by the Constitution of Uganda. The English language is a foreign language, and meaning is found in either legal dictionaries or reputable dictionaries in the world. And therefore, the word tribunal court, which is an English language word, must be defined. And I say Article invite you to check the word tribunal so that we do not undergo threats of being imprisoned for using the word tribunal. It's not derogatory. It can be used interchangeably. And what I'm really hinting at is that the interpretations of the judge advocate must be as closely as possible to reality to avoid misleading the court into acting in a manner prohibited by the Constitution of Uganda. I hand over to my colleague.
Thank you, Mr. Chairman and members. Mr. Chairman, I just wanted to substantiate these issues with prayers. Number one, Mr. Chairman, issues raised by Senior Counsel are quite fundamental in the administration of justice. Before you go by this court martial, from the list read by my friend here, Counsel Conduct, the name Kizza remains on the list as one of the advocates representing the chosen passports. Mr. Chairman, we seek your guidance on how that is going to be handled, because the instructions still stand that it should be part of the team, despite what transpired the last time we appeared here, the proceedings of the Southern Court. Mr. Chairman, we're wondering whether there will be orders, but every time the proceedings come, you have discretionary powers to be produced here to execute the duties, and then maybe his return. But we leave it to you, Mr. Chairman, to guide us on how we are going to deal with that, because it's a matter which touches legal representation of the right of fair hearing, initially in Article 28 of the Constitution. And as we indicated earlier, there's a specific role he has been assigned in representing the chosen persons. So we beg to be guided, Mr. Chairman, in how kizza is going to continue featuring these proceedings as one of counsel. And we ask that you pronounce yourself on this particular matter. Two, again, we ask, Mr. Chairman, that you pronounce yourself on the validity of the proceedings conducted when the tribunal, rather the court martial, the panel changed. When the panel, the composition changed. Because as per Regulation 26, Mr. Chairman, the sub-regulation 1 the order convening the court and the names of the officers appointed by the accused person shall be read in the hearing of the accused, who shall be given an opportunity to object to any of those officers. Indeed, at the commencement of the proceedings of day one, the names were read. But subsequent to that, as highlighted by my senior colleague here, the panels kept shifting. So, the panel that was announced on day one is the panel that ought to have continued. Even on the day Kizza was tried, summarily and convicted, it was a totally different panel. So, Mr. Chairman, we beg that you pronounce yourself on the validity of the proceedings that transpired after the panel had changed. And that is also fundamental in line with Regulation 26 of the regulations of this court-martial. Now, on the question of intimidation of lawyers, it's a very serious one. We beg that you critically reflect on this. We are concerned that the war environment is not conducive for dispensation of justice. As she has noted, and we are on record, you can see our numbers are shrinking. They are shrinking because of the intimidation which is present. There are orders that were made by you, Mr. Chairman, that all the officers manning the processes right from the point of entry should be clearly identified. They should have name tags. But we continue to have officers who are obeyed, whose faces are not even recognized, who have no name tags. So we don't know who we are dealing with, Mr. Chairman. And this is a known practice. I can see, Mr. Chairman, members who are part of this tribunal, Mr. Chairman. Their names were announced to us. And it's not without a reason that that provision was enshrined in the rules governing the proceedings before you. Why should we continue to have officers all over manning the courtroom here, manning the premises, handling all these the protocols here we go through? We cannot easily identify. And they create the environment to be very, very inimical to dispensation of justice, very hostile, Mr. Chairman. And this is a key tenet of the due process, and it's a key tenet of the right to fair hearing, which is the bedrock of our criminal justice system in this country. We request that, Mr. Chairman, you make the environment conducive for administration of justice. It's a well-known principle, Mr. Chairman, that justice must not only be done, but it should also be seen to be done. So it should be manifested in the proceedings, in the way all the processes are conducted, and in the way we are treated. But, Mr. Chairman, the perception, real, and the reality is no conducive environment. And finally, Mr. Chairman, on the nomenclature here, which is turning out to be controversial, the issue of the tribunal. I thought they wouldn't be fast about it, because we use these terms interchangeably, even in the course of judicature. Mr. Chairman, it has happened even in the Supreme Court, to refer to the Supreme Court as a tribunal, to refer to Chief Justice as an arbiter. And the Chief Justice does not take offense. And to refer to his office as an arbiter, or to refer to him as an arbiter. The Chief Justice does not take offense. Ordinary courts of law do not take offense being referred to them as Now, I'm worried if that is going to invite disciplinary proceedings, just even if it's a mere slip of tongue, that is going to invite disciplinary action. That sends chills down our spines, and it has a chilling effect on the execution of our duties. That chilling effect is so fundamental in the dispensation of justice. If I may ask, Mr. Chairman, I have had some of the officers here address you as your lordship. They say, my lord, my lord. Yet, for us, we are addressing you as a chairman. Would that also be taken to be undermining this court? That we're not addressing you as my lord, that we're addressing you as a chairman? And if the judge advocate and the entire panel shouldn't take offense about this, we can interchangeably refer to you as a court, we can interchangeably refer to you as court martial or as a tribunal, because they all mean one and the same thing. But one fact remains, if we are talking about courts of judicature, that's a different matter, Mr. Chairman, because courts of judicature are well defined under the Judicature Act. And that is a different matter. So if I said this general court martial is not a court of judicature, I am stating facts within the law, under the Judicature Act, under the Constitution. That is not a court of judicature. And that is a fact. So, Mr. Chairman, I beg that you do pronounce yourself on those matters, fundamental, and the dispensation, in regards to the dispensation of justice. I beg to move this.
My name is Samuel. Mr. Chairman, I raise two issues. First, whereas this side a better conducive environment this morning, the same was extended outside. Some of us have to walk a kilometer to court. Right from the T-junction, we are faced with the blockades. I don't know why council cannot be given access to park within the premises of the court. I believe this is one of those issues that have to be taken seriously. How do I carry a box full of books from the T-junction or in the fields where we are being pushed to park? I think this should be addressed. We've seen a large parking space up here, in the premises here. So that should be handled, Mr. Chairman. Secondly, are we truly constituted as a court in the absence of reserved members of the court martial? We need to be guided on this issue too. Right. Mr. Chairman, short one, regarding what my colleagues have said, vis-a-vis using the word interchangeable technology. Mr. Chairman, in our Constitution, Article 151, which is at page 130, which touches on courts or forum, not necessarily underlying court, which is just a matter of expression. Kindly request that that's the in line, based on the Constitution, so that it is not taken to be demeaning the membership of the family.
Let me summarize this. We'll start from the bottom. Counsel Mulimba. This is what Counsel Mulimba said. By the time I came, I did not even see anybody in the room. So I can't tell unless I have to consult who are managing the security. But on that one, I can't tell much about that because by the time I passed there was nothing. But
Is the
if
volume
I'm not
back?
mistaken,
Is the volume back? You let me know because it is about the network. It is not about the volume putting it down.
much as you want to bring us in almost all issues, I think somehow some of you need to bring yourselves. Counsel Club, you have been talking everywhere what you are intending to do. And I think they cannot be taken lightly. Because we need security. People who come here need security. And we don't know the tactics you want to use to destroy this court. We don't know. So security also have to check if they have been checking people who are coming. I think that's what it's all about. Because I don't know what they were asking you, what they were telling you, I can't tell. But I believe could have managed maybe from those statements sometimes you make. And on Counsel Aaron, I don't know really what you are pushing because I've never had, unless you will guide us also on that one. The person who is serving sentence to come and attend the court that can be advised on that. Senior counsel, I don't know, you said, I don't know where this one came from. You know, of course, you are from Kenya, and Kenya is part of the East African community. So I don't know that one where it came from. But I think even the villager wants to serve from Kenya or Tanzania. It's good you have talked about the conduct today, and you remember it was raised the other time, and you said I'm going to talk to these people. And that's what we want. We are not here just it's not a war. And I don't know why you are looking at one side, you are not looking at another side. People making noise in the court. To the extent of even of standing on the chairs which they are not supposed to sit where they are supposed to sit. Singing is not a court. Or you want to make us, you are either provoking us or you are, I can't tell why you are doing that. What we need is to conduct yourselves in the manner you are supposed to conduct yourselves. This is a court. I've seen it everywhere at once. The council or anybody is submitting, everybody is listening quietly. You finish another one. If this side finishes, another side also, so that we proceed without any problem. I don't see where confusion comes from if we are following what we are supposed to. Unless, if you have, especially Counsel was asking about my vote versus chairman, and then the reserve members. Sir, I will take the opportunity to respond to the legal issues arising from the submissions of defense lawyers. And I also refer them to carefully Regulation 63, which talks about the duties of the judge advocate. Regulation 1 says that the prosecutor and the accused respectively are at all times after the judge advocate is named to act at the trial entitled to his opinion on any question of law or procedure relative to the charge of trial, whether he is in or out of court. And the accused and his lawyer, that's what it means. So any legal issues arising, I am mandated to advise this court. To begin with, calling this court a tribunal, that one will not happen. The UPDF Act defines court-martial as a field court-martial, general court-martial, or court-martial in court. That is what a court-martial is. Even in the Constitution, it is there that you can, the DPP can have superintendent over all proceedings apart from the court-martial. So to say that we are going to borrow definitions or to have slips of tongue, I think me as the judge advocate of this court, you must call this court a court-martial. That is the name that is in the UPDF Act. We are not going to adapt dictionary definitions. Secondly, the issue of kizza as one of the lawyers. I also direct you to read Article 28, Clause 3, Clause D. Sometimes I never to read because when I refer to read, they say I should read, so I will read. It says every person who is, right, that's the right to a fair hearing, every person who is charged with a criminal offense shall, when you go to be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled. However, gravity of the offense, you cannot say that when we have 30 lawyers here, Kizza, who was convicted by this court, is not there, and therefore the right to fair hearing is violated. Then what would be your role here? All the lawyers who are here, if I may ask. Or can I say you are going to say it's a constitutional violation because a person who was convicted court is not there and all the over 30 lawyers are here, that the right to doctor is violated? My answer is no. And if you want to seek constitutional interpretation, you can seek a constitutional reference on that. My understanding here, they say a lawyer of his or her choice. You can have more than one if you can, but to say you can be 30 and Kizza has a specific role, to me that doesn't make sense. I think I'm done with that. About the environment not being conducive, the person raising this matter is ably submitting before this court. How can you say the environment is not conducive when you are saying all what you have said? Counsel Kwabo, for me, I don't understand what you are saying. Then, the issue of court members, when we started this session, all court members, including those in reserve, were present, and all of the members before you have been following this case, have been reported. So the fact that you are seeing one is not there, whoever is there has been here from day one when this court started. So you cannot say that these are new members, we have an instrument appointing the members. You can cross-check. They are there and they have never missed any session when we are sitting. So there is nothing that members are changing without notes. That one also has not happened. The other aspect, I think the last one, I think the one raised by Counsel Conduct, I will not go into it because I have already given my position. But Senior Counsel Karua said that me, as a Brigadier Tukachungu, I called you that you are a foreigner. I have to ask you if you have that proof, and which I never did, I will apologize. And if you don't have it, I also request you to apologize for saying I said you called you a foreigner. We have interacted, but now it has never come out of my mouth. That is my response.
Yeah, Mr. Chairman, remind my friend here that it is actually on video. You refer to me as a foreigner.
You bring it.
And everybody remembers it has caused a lot of heat on social media.
No, bring it. But I never said so.
Court members, we are going to proceed. This case was which court has not pronounced itself on. There's no prior at all regarding the proceedings where the ban has been shifted. That's not true. It's advertising the court. It's not that it's not. He was advertising to tell us this is alleging that they are changing. Can he say what's wrong?
This is like this council class. Members of this court.
But if court pronounced itself on the matter, if you feel that you have proof that the court was not fully constituted, you have an avenue of appealing and challenge the decision of that court. But you cannot raise it here that court is going to pronounce itself. Court was properly constituted, it took a decision. Now, for you who is aggrieved and saying no, then we have a controversial court. Appeal with proof. They will give you an answer.
Therefore, kindly give us a list of those who sat at the sentencing session for Aaron Kizza, because we noticed there was a change. If you gave us that, it will help us in the appeal you have directed us to, because we definitely will take up the issue. But there's also one issue he has mentioned. He has said that if we are not happy with the interpretation, we can go to the Constitutional Court. So I actually rise to seek to be referred to the Constitutional Court on several issues, not just on that one issue. And one of the issues is actually the jurisdiction of this court-martial. I was looking at we have looked at the Uganda Constitution of Uganda, Article 208, which sets up the Uganda People's Defense Force, and Article 209. Nothing in those articles expressly or by implication gives the UPDF civil or criminal jurisdiction over civilians. And this General Court Martial was created through an amendment of the UPDF Act. And it is our belief that an act of parliament which amended the UPDF Act cannot amend the Constitution of Uganda. And that the Constitution of Uganda, the basic structure, which is about how duties are divided through the three arms of government, only the judiciary has the exclusive jurisdiction on civil and criminal matters, and that UPDF can only discipline its own members. These two gentlemen are civilians. We therefore want, among other things, interpretation of that. We also want the interpretation of the fact that what do we mean by lawyer of choice? And by arresting and sentencing Aaron Kizza when he is in court as an advocate. And the issue was the success beyond that bar, where now all these advocates are sitting. There's nothing else he wanted. He was saying, I will enter. Has that interfered with the right to representation of these two gentlemen? Is it an act that undermines the preparation of the defense of these gentlemen? We have several issues that we would like to refer and which we are going to draw your attention. If I may, I want to go over 2 or 3 of them and ask my colleagues to supplement. The first one I have indicated.
I thought you responded.
You asked us to refer matters of interpretation to the Constitutional Court, and I am now seeking a reference to the Constitutional Court.
Madam Chairman, what I think is further to Madam Chairman, I think she will need to address herself on the procedure, especially on references under our rules, Constitutional Court application and reference rules. And I don't think by submitting that she's seeking a reference from this court, that's what the rules provide. It doesn't provide that. There is a procedure that is provided for under those rules. Therefore, Madam Chairman, I pray that we proceed with what the merits of the case are, instead of going against what the rules of reference provide. I so.
And maybe, sir, on the question of whatever you have raised, I have responded. So I don't see how you open again. The question of jurisdiction was the first thing we dealt with when before I took even the plea. And the ruling of court is there. So we cannot again go backwards from where we started. So all issues are resolved. As I read to you, regarding advising on legal matters, I've given my advice. So I beg you to proceed with the chair. Maybe Counsel was saying, calling you my lord, chairman. Nobody has forced you to say my lord. Even if you say honorable chairman, it's okay. But even if you say my lord, that's upon you. You cannot start challenging him that those calling you. He has not requested anybody that call me my lord. You can call him honorable chair of the court. It's okay. So I don't think even it's a question worth asking him that he respond. There's nothing to respond there.
Mr. Chairman, just before my senior colleagues come, again, just for consistency, we kindly request
Let's not repeat what has been said and answered.
I'm not going to repeat, Mr. Chair.
Yes.
I'm only asking that because we are many, if we could kindly follow a process whereby if a matter is raised before the Honorable Court, we understand that the role of our colleague is to advise. So we take it that when advice is issued by the judge advocate, the matter then returns to the court to make a finding so that the matter either rests or is left pending. And why we're saying so, Mr. Chair, for example, is that there was no finality before I say that. Otherwise, Mr. Chairman, it will appear then that if an issue is raised by counsel and the judge advocate issues advice and the court does nothing after that advice, then it means that the court is bound and subject and subordinate to the judge.
Why am I raising this? Otherwise, my Lord, there appears to be a difference between counsel and the judge advocate. Regarding the issues raised in housekeeping, there has been no adverse position from the state. In the other setup where we work, when you don't refute, you accept. And it appears then that the judge advocate is either coming into the realm of the state and also taking over the role of court. Why am I saying so, Mr. Chairman? There was an issue regarding the composition of the panel. And we take it, Mr. Chairman, that all the honorable members of the panel are part of the decision-making process of this court. The benefit we have is that when all of them are present, it is possible to follow the events, to look at witnesses, and come to an agreement. It would be unfair to Mr. Karibala, for example, if he read his evidence before me, and then he's cross-examined before Mr. Chiwanuka, and then the decision is made by Mr. Kawa. There is a break in the chain. So we kindly ask, before we go any further, Mr. Chairman, that the issue of the panel is completed. My neighbors whispered, and I'm sorry if they are wrong, but at the last sitting, your neighbor to my right exactly was not on the panel. I don't know why any particular member here identified only her, I don't know, but they insist that she was not on the panel. Other members before have said that there was one lady, now there are two. I think that causes a concern, and it may go back. So it is an issue that if we break the consistency of the panel which constitutes the court, then the judge would advise that they are following, they may be following from somewhere, we don't see them here, but we bear in mind that the interests we are representing are for their persons, that they themselves, no matter the decision of the court, must be satisfied that the process has been fair and has played in accordance with the rules. So, Mr. Chairman, if the rules say that the members should be here, and it is good that they are here, so that, and I think that's a simple matter. If they say the reserved members are here, I don't direct, but perhaps the court can get a center so that we are happy that they are there and we see them and that we sort out. So I request, Mr. Chair, before and maybe we first state the issue of the reference, that we put to finality the issue of the panel. Because again, if we make submissions regarding whatever I want to say, and the court has to retreat, or the state has to ask for the time to consider, and the next panel is not the same, we will then have to make the same submissions just so that the person making the decision here is out.
Mr. Chairman, on the same, my whisper was not quoted by him. I didn't want to stand again. I wanted to bring it to his attention that actually the neighbor does not have a name tag, just like the others. That was the observation. And it's clarified. Secondly, I think my issue of parking includes access, my access.
There is an advocate with who is.
I'll not come back to this court if I'm parking 1 kilometer away. Access includes e-parking in the premises. I think that needs to be also clarified by this court. We need a conducive environment as counsel. I will not carry box of books like I did today, 1 kilometer away from here, Mr. Chair.
I'm sorry, my neighbor is killing me. He says they say I should insist that the person who was sitting to your right the other day, in their view, appeared to be a gentleman, they alleged it is a name of Kalebo, and the collar was red. So we don't know whether so we don't know whether the person today has not the red part. But my lord, as you can see, it's the concern that the people here in Besigye, when they are changing, there is a concern that may not be had fair and square. It's our polite request, Mr. Chairman, that the court makes a pronouncement before we go further regarding the consistency of the panel constituting the court. I'm sorry, of the panel constituting the court.
It's all right, Counsel. Yes, the other day there was a panel here, as you have said, but as you heard from Judge Advocate, we are 19 members. 27 are supposed to be here, including me, and then the reserve is supposed to be behind there, so listen. But maybe some would have misplaced going.
There are few.
You can see it's that when the case one maybe have a problem of fees, you can go out another one can. That's how we usually operate. Unless we add on something, but that's how we operate. Then the accessing the court. Counsel, I may answer maybe from the gate here, around this premise and inside here, but outside the premise, I mean the gate, I may not have an adequate answer for that. And
I think so what I can inform the lawyers is that this part of the court is consistent of composed of 7 members before it can conduct business on any case of a capital nature. We have 7. There is now no case arising before this court where Major Sara was not present. So we are ready for the case from side.
Mr. Chairman, we need to put this into context. The spirit of the rule that requires that the name be declared at the commencement of the proceedings. The spirit is very clear. And actually it does not stop there. It requires that if there are objections to any of the members, the accused person is at liberty to say so. So if the panel keeps changing, like we are told, Captain Okaleko, Sleep, Kano came in just to replace the one who had been on record before without any procedure being followed. That goes to the root of the proceedings, the validity of the proceedings. That I've not had the pronouncement of the court martial, the validity of the proceedings, because it was not done at that, on the day. Actually, Aaron Kizza was summarily tried and convicted when Captain Okaleko came in. Sorry, Colonel Okaleko came in. Sorry. When Colonel Okaleko came in, there was no declaration made. And I've not had any pronouncement on the validity of the proceedings which were conducted in outright violation of the regulation that requires that you make a declaration that this is the party that is going to try you. So this is the whole point we are making, Mr. Chairman. So if, Mr. Chairman, we continue operating like this, then it's a negation of not only the spirit of the Act and the regulation, but the Constitution itself, which Constitution is what is establishing this very court martial. So, Mr. Chairman, we need, like, in reinforcing the submission of my grand friend, very powerful. Let the court make a pronouncement, a decision.
Counsel, the culture here is once a chosen person is brought to the dock for the first time, he is introduced to all members here and to members, which was done on that day. So this, or changing of position or operation, just is when we are proceeding. Or maybe, unless you are asking that, where is your Karibu now? That's what you are asking.
Not only that, the validity of the proceedings, the legality of the proceedings, where a member of the panel is not introduced because Captain Colonel Okai was never introduced to the accused person. This is the point. Already accused the persons. This one's in the dock and the already chased because he was also put in the dock as brief. So Okalibo was never introduced to the accused person.
I think you could have forgotten, but that is the thing that is done on the first day when the accused persons or persons appear in the dock. And they are asked, and they answered. They had no objection.
My people, I'm sorry about the volume. I'm sorry about the volume. It is only.
You cannot say that Chiza was supposed to take a plea. He was supposed to be defended. There is nothing like that when you are in contempt of court. Contempt of court, you must understand about how it is, the whole process works. So you cannot say that the panel was not introduced to him. Those procedures don't apply.
But I think you need to close the chapter of Chiza because he was convicted and sentenced. If you are not satisfied, you know what to do. That one. I think let us proceed.
He's still on the part of the lawyers.
So should we adjourn up to his fixed sentence?
It's the guidance we are seeking from Mr. Chairman. How do we deal with this?
About
has instructions.
About the convict, the one who is sentenced, who is serving the sentence.
But he still has instructions, Mr.
So which
Chairman.
means all of you cannot proceed.
I think it is very important what the judge advocate is giving as advice to this court. And I will here now declare that I've been a judicial officer of the rank of senior resident magistrate. And even in contempt proceedings, you cannot sentence an accused in their absence. You must put the contempt to them. So we are saying that procedure in this country is very important and it is of utmost fundamental importance, the advice given. And when we object to the advice given, it is important that the court, in accordance with the rules of procedure, pronounces itself. You are expected to side with the judge advocate, or for good reason to differ with him, because we are objecting also based on law, so that you are given the correct procedure. What happened to Aaron person happened, and he is going to take action accordingly. But if moving forward, the proper procedure is not applied, then we are at risk. That's what we are saying.
I think, sir, we need to move forward, Mr. Chairman, and we close the chapter. All matters are with the
we are closing the chapter, but what I want to tell the first attorneys is that just feel free, unless you conduct yourself in a manner that is befitting you. This business of making noise, stand up, we go, we do what, that one is not going to be allowed. You do that, you are very responsible. Let us conduct ourselves the way we are supposed to conduct ourselves. We listen to each other and we proceed.
Mr. Chairman, allow me a light observation, Mr. Chairman. On the issue, yes, much obliged, Mr. Chairman. On the issue of changing the panel, Mr. Chairman, it has far-reaching consequences. For instance, Well, when the ruling which resulted in street sentencing my learned friend Aaron Kizza was being read, reference Colonel Okalebu was not present in 2024. However, he participated in sentencing Aaron Kizza. It has far-reaching consequences, Mr. Chairman. Indeed, something must be done. I thank you.
So I think you need to give them the list, the other instrument of ours, so that they understand the conclusion of this code.
We have our one and they are also advocates. They are sitting, don't just sit in their clubs. The media and the one next, they are also advocates. They manage our registry, it is also under my office. So you can ask anything. If it is an instrument of appointment, we have it.
Go ahead, go ahead to this state.
Mr. Chairman, just the last one, the very last one, it touches me personally. Mr. Chairman, it touches me. Mr. Chairman, I beg, Mr. Chairman, your indulgence, Mr. Chairman, I thank you. This is the very last one, Mr. Chairman, which you raised in your communication, Mr. Chairman. Mr. Chairman, if I may be permitted, Mr. Chairman. Mr. Chairman, I beg.
I think some lawyers cannot speak at the same time.
I am seeking for the indulgence of the chairman.
But he has not
It's a humble, you know, and
this is what we are saying now. Because if you are to conduct ourselves like that, then we don't see.
Because, Mr. Chairman, we are dealing with matters of life and death.
Since we started, we are talking. Now let's say.
Mr. Chairman, it all depends on the gravity of the matters we are dealing with. The sentence we are talking about here is death.
Chairman,
the charges is death.
I suggest to rail on Counsel Conduct to respect the chair and vote. People lawyers cannot speak at the same time when you are both standing. It's very honest.
Council Raphael, proceed.
On the 7th of January, when this matter came before this court, I concluded this court that we intend to amend the charge sheet. But because of some administrative matters, we could not proceed, which happened in court. So, Chairman and court members, we want to amend the charge sheet and we are amending this charge sheet pursuant to Regulation 66 of the Conduct of the First Process and also procedure. It is premised on the need to ensure that justice is effectively administered by holding all parties accountable. So during the course of investigations, some facts revealed that there is a serving UPDF officer who is connected to the offense. So we intend to have the charge sheet amended by addition of that officer. And we also intend to amend the charge sheet by adding there another count of treachery. So those are the two amendments we are seeking to amend. The person who is introduced on the charge sheet is Article 743, Captain Dennis Ora. The Ugandan, a soldier of regular forces of Uganda for the defense forces. is attached to amendable date.
Sorry, this is part of the particulars of the
So it is an RO 74(3) of the Genesis Quran. It's an office attached to Ahmad Debate. And we are also acting there the public of Treasury, which will be housed too, including the officer and the two accused persons. Those are the amendments we seek. Wow.
Mr. Chairman, we object to the amendment, especially before the ruling of jurisdiction. In fact, we stopped the application for reference to await the ruling of jurisdiction. We feel that amending to add a person who is serving in the military is meant to preempt the ruling on jurisdiction. So the court has no, it's in our view that the court has no jurisdiction on these two gentlemen. And we see that the ruling precedes the amendment of the charges. When we then can raise full objection, because the charges, the amendment is not sought properly pursuant to the rules of procedure.
Counsel, which ruling are you talking about? Ruling are you talking about?
On the ruling that you referred to, Mr. Mkwabo, having on your jurisdiction. There is a ruling you've been seeking to deliver ever since we came.
From the Supreme Court?
From yourselves, from this court martial.
Not the ruling. In short, the ruling is the ruling which was delivered on the same day it took place.
Mr. Chairman, we have been under the impression that in several occasions that was supposed to be delivered. That only relates to matters that were raised the first time the accused persons were charged. That matter, I think, has something to do with jurisdiction. It has something to do with the extraterritoriality of some offenses or how we put here, and therefore it's quite to justice. So we have all along been under the impression that it is in fact a ruling. I don't recall my land faith profile once actually rose and said we are ready to proceed. But the events that have taken place since last time have taken that. So we are keen on receiving the ruling. Mr. Chairman, that is point number one. Point number two, which relates to what the Fred has just prayed about the amending charges. I am looking at the rule that was cited, and it talks about amending charges where it is stated the name or description of the accused, or a mistake which is attributed to clerical error or omission.
did say that in the charge there had been reference to the serving officer. I haven't seen that reference in the charge, but I don't think that calling somebody a serving officer is a clerical error or omission, so that now we have found the name. You must have known the name, but just refused to put it there. So I'm not sure that regulation 66 allows him what he's asking than to join Captain Davis. So I just rise on those two issues. Ruling, but I don't want to go that way.
Mr. Chairman, for the record, I'm Louis Basinalukoi. I associate myself with submissions of my senior land friends. Mr. Chairman, the move by the prosecution is a calculated way of defeating the defense which has already been brought to your attention through preliminary objections raised by my senior land friend, Counsel Elias Lukwabo, when he objected the jurisdiction of this court. And indeed, there is a pending ruling. The other time when Senior Counsel Martha Karua came, we were not allowed to proceed with receiving the ruling, awaiting the grant of a temporary practicing certificate to Senior Counsel. Indeed, Mr. Chairman, there is a ruling pending before this court, and the prosecution is trying to, yes, if the prosecution refers to the notes they've been taking, they realize that indeed when we compare the same with ours, there is a pending ruling and they intend to preempt the ruling, Mr. Chairman. Don't allow them, they will be defeated. Yes, yes.
Mr. Chair, just for recollection, maybe recalled when senior colleague Parua last year raised application for an adjournment for an hour, and court wasn't ready. Court graciously granted us 15 minutes. At that time, the business of the court before the adjournment was to deliver a ruling regarding matters raised by Mr. Elias Lukwabo. That was overtaken by events because when we came back in the afternoon, we did indicate to court that there were issues regarding instructions received by him and also the matter of Mr. Kizza. So it is correct, if I recall, that it was at my request that we are granting an adjournment of 15 minutes so that we come back and issue the ruling of the House. Perhaps, Mr. Chairman, it may be necessary for court to retreat for 10 minutes just to confirm that it is correct that there was a pending ruling. That was issued. Thank you, Mr. Chairman.
Counsel, honestly, I'm glad that the regulation 66 1 that we will proceed to paragraph 2, which states at any time during the at which there is a judgment, it appears to the court before it closes the 5 minutes finding that it is desirable in the interest of justice to make any addition or omission. So that is the idea. I'm moving so-called addition by addition because this is during the course of the investigation. Additional evidence was got and
counsel just a brief join rule 66. I had read this rule 2, but my interpretation of sample 2 suggested that it only applies when we are at a stage where the court is close to the deliberation is finding. We are still at the initial stages of this matter. So I still submit that either to the judge under this rule 66. 66.1 doesn't help him. 66.2 certainly destroys his attitude.
Allow me, Mr. Chairman, to add just one thing.
My lord, they have no locus.
We are relying on a matter of law to your application. Actually, the rules are so strict that once you charge an accused person, other than errors in name, and at the stage of deliberation to make a conclusion, where the evidence may have revealed a different charge, you cannot add other accused persons. That's our reading of that particular regulation, Regulation 66(1) and 2, and we are asking you to make a finding that they cannot amend at this stage. I want to thank the prosecutor for admitting that indeed we expect a ruling from the court of the area.
The court is adjourned for 10 minutes.
Okay, the court is adjourned for 10 minutes and we are taking a break of Besigye uli awubira abantu Davis. All right. Court has taken a break of 10 minutes. We are coming back in 10 minutes. Still to sawa kumkwatira keddakiika emu yokka nkwatako mu nsawo yange. As you see what is going on here, court has taken 10 minutes for a break. See how they can come around. See how come around. As you see everything here.
Kasozi. Olina Newton.
Waliwo.
Yanga ndi akoza simu yawe bangi kuba kadi jeko. Newton. Hey.
Sabugwao.
Musajja wange mulete tosobola.
Kasozi mungambireko live ngenda mmoja wano wabweru bakotya omuddemu dakika 10. Shining bulala no hata msekatokea kuba kufango lawe litanse choleta bichobale tanga
No worries. Counsel, a minute. Briefly, agenda tubulirako tuwumuddemu eddakiika 10 chairman asabye kooti ewumulemu eddakiika 10 nsonga kitulabye nga Kano Kizza Besigye ne munne Obedi Lutale waliwo omusirikale abwegasseeko munda ayinza okuba nti agambibwa nti oba ayina akakwate ke yateeka. Yes, tulambululiremuko n'abatulaba wano
kakati olwaleero tuli wano era tufulumyemuko katono naye kireese ekyo chairman wa kooti awumuzaamu kooti eddakiika 10 nga ekireese kino ku mulundi ogwasooka omulundi gwe twasembayo okubeera wano bagezaako nnyo okwagala kooti ekole ruling gye twali tulinza okumala ekiseera naye bo bennyini olwaleero batwewunyisizza ate nga chairman wa kooti agamba nti takimanyiiko nti kooti eno erina ruling gy'erina okuwa. Naye omuwabuzi w'ekkooti yamanyiddwa nga jjajja advocate amutegeezezza nti ow'ekitiibwa chairman w'ekkooti waliwo ruling gye tulinda era eteekwa okuweebwa ne ku mulundi guli twali tulina okugiwa. Ekyo nekisapootingibwa ne omuwaabi wa kooti eno mwami omusirikale naye n'ategeeza kooti nti ekyamazima waliwo ruling gye tulinda. Ekintu chairman wa kooti kyagamba nti ye abadde takimanyi ate nga ku mulundi guli ye kennyini yagamba nti ruling weeri erirwedde tugenda giderivalinga oba Martha Karua tannaba kufuna practicing certificate ye tugenda kubawa ruling. Naye olwaleero munnange kirabise nga ruling erabika ng'eteriiwo completely. So ekyo kireetedde omulamuzi okugetinga confused oba chairperson ne judge advocate nga tebali ku page eno.
bw'atyo chairman wa kooti mwami Freeman n'agamba nti kooti kewummulemu eddakiika 10 ndowooza bamale okwetereeza bekakase oba ruling weri oba naye nga ruling weri era tugirinze okugituwa. Ekyokubiri, tulina ekintu ekipya kye tusanze mu kooti olwaleero. Omukulu chairman wa kooti ategeezeddwa omuwaabi wa gavumenti nti balina bo nga aba gavumenti munnamagye omulala akola ne Amadi Brigade bamuyita Ola, Dennis Ola, gwe baagala okwongerako ku musango gwa Dr. Kizza Besigye ne Obedi Lutale, nti era naye okusinziira ku kunoonyereza kwabwe yasangiddwa nga y'omu ku bavunaanibwa abalina okuteekebwa ku musango guno. So n'olwekyo nga basaba ekkooti nti tegenda mu maaso na kuwuliriza musango guno oba esooka eyimirize okugenda mu maaso n'omusango bamale okukyusaako mu mpaaba yaabwe bayongereko omwami oyo. Ekintu ffenno kye tuwakanyiza ddala kubanga ffe tulowooza nti ekyo kikyamu era kigendereddwamu kulemesa chairman wa kooti ne kooti ye okutuwa ruling olwaleero. N'olwekyo ffe bwe tugenze okukebera amateeka gennyini gayagala okuyitiramu okukyusakyusa mu mpaaba yaabwe okwongerako omuntu omulala, mwana wange tegamukkiriza ate kwongerako omuntu omulala yenna mu stage gye tuliko. Tusomye rules ezo era ne tutegeeze kooti nti amateeka gennyini omuwaabi wa gavumenti gabuulidde kooti ate tegamukkiriza ku addinga okukola kye tuyita amendment to the charge sheet mu kiseera kino. So chairman bwatu n'awummuzaamu kooti eddakiika 10 ne tufuluma ebyo kati tulinze ate kuddayo.
Briefly in English, some people are watching you from California and the outside of the country.
Yeah, so I was saying that today we are back here at the General Court Martial. However, right now the chairman of the Court Martial, Mr. Freeman, has told the court that he needs to adjourn the court for 10 minutes to have a break and they deliberate on issues they want to deliberate on. But preceding that, in court, they informed us that they intend to amend the charge sheet. They intend to amend the charge sheet to add on another serving officer of the UPDF under the names of John Ola. That John Ola is a UPDF serving officer who works with the Armored Brigade. They are saying that they intend to amend the charge sheet to add him on the charge sheet. Something we are saying is wrong according to the law. The prosecutor has provided the laws to the court that allow him to amend the charge. However, when we read the same laws he quoted to court, we realized that the laws do not permit him to amend or add another party at this stage. So there was an argument forth and back in court. That is one limb of it. Then, as we were still in court, it happened that the judge advocate did not remember that we are waiting for a ruling. It is clear that last time we were fighting a battle between them, not wanting us to wait for the ruling, and they wanted to deliver the ruling. On that day, the prosecutors were fighting hard to ensure that the ruling is delivered. Today, the judge is not aware that he's supposed to deliver a ruling. Mr. Freeman, the chairperson of the court, is not aware that he's supposed to deliver a ruling, but it is on record that himself last time, he said that even if Counsel Kizza has been convicted, Martha Karua had not secured her practicing certificate, the court was ready to deliver a ruling. However, today, the chairperson has surprised us by saying that there is no pending ruling to be delivered. The judge advocate advised him that, sir, there is a pending ruling. He still didn't believe the judge advocate. The prosecutor said the same thing, that there is a pending ruling, Mr. Chairperson. That is when he said that right now I am adjourning the court for 10 minutes. Probably, we are presuming that they have gone to consult and come back with one position. So we are now in the 10 minutes he has given and waiting for what is happening and to be called back to court.
Thank you very much, Counsel. Tell us the position you are coming at, probably in your constituency.
Yeah, I am coming. I just want to inform the general public and Ugandans generally, but specifically the people of Katikamu South constituency, that I am your next member of parliament for Katikamu South. I am coming to stand as a member of parliament for Katikamu South constituency. The abuse of human rights in this country requires a freedom fighter, requires a human rights fighter. So in Katikamu South constituency, we can no longer have incompetent people representing us in parliament. So I'm requesting that the Ugandans in Katikamu South constituency consider me because I'm the best candidate so far. That is the position. I'm going to parliament.
You give it us in Luganda.
Yeah. Njagala kutegeeza bannayuganda bonna okutwaliza awamu naddala abo abali mu Katikamu South constituency Luweero